A couple days ago, I guess, Governor Morrisey signed an Executive Order 3-25. And in that executive order, he prohibited state agencies or any entity receiving state funds to utilize those funds for a number of DEI or diversity, equity, inclusion related programs or activities. While the governor has broad authority to regulate the policies and practices of government agencies, the problem with this order is that it is overbroad, meaning that it not only applies to programs that the government can regulate, but it also applies to situations including higher education classroom instruction that the government cannot regulate because higher education classroom instruction, professors have academic freedom rights, which are protected by the First Amendment. So the way that this executive order is written is overbroad and applies to situations that the government really can't properly regulate. The admissions or hiring practices of institutions can be regulated in this way by the governor. And the problem with, from fire's perspective, we don't take a position on affirmative action related hiring policies. But our issue area is, excuse me, our issue area is peaked when the governor does cross these bright constitutional lines into regulating the sort of activity that can occur within college classrooms, the teaching that is occurring. So blanket bans on or prohibiting discussing or teaching certain ideas in college classrooms crosses clear constitutional lines that the Supreme Court has protected for decades. Governor Morrisey was asked about this executive order and the possible overbreadth, or from our perspective, the clear overbreadth of applying to college classrooms. And it seemed to me like there's an opportunity for us to get these lines drawn right before the executive order really takes effect or before the institutions try to start enforcing it. And frankly, putting the universities in a position where they have to follow this executive order or follow the First Amendment. Universities should be following the First Amendment. Executive orders cannot trump rights protected by the Constitution. But we're hoping that the governor will issue some clarifying language to make perfectly clear that this does not affect teaching in higher education. And my understanding is that the legislature is also considering legislation to similar to what the governor's executive order seeks to do, and we'll be working with the legislature to ensure that these bright constitutional lines aren't crossed in the legislation either. I don't have any speculation about the cost of litigation, but certainly the ACLU and other groups, if this order is to take effect and if the institutions start enforcing this order, um, I think that there are a lot of options on the table moving forward, but we hope we don't get to that point. We hope that there is proactive action by the governor and the legislature when they're considering these bills moving through the chambers in the legislature, that they take our concerns seriously and ensure that classroom instruction, research, and publication by faculty remain unencumbered by these overbroad orders.
How?
So, we put out a press release last week, included our press release links for faculty members whose teaching may be impacted by the executive order to reach out for us. And if we find that institutions are enforcing this executive order in ways that violate faculty member constitutional rights, we'll consider every option moving forward. Dating almost 70 years ago was the first time the Supreme Court had a really clear case of protecting academic freedom, protecting the rights of faculty members to discuss ideas in the classroom, in a case called Sweezy versus New Hampshire. In that case, in Sweezy versus New Hampshire, the Supreme Court wrote that teachers and students must always remain free to inquire, to study and evaluate, to gain new maturity and understanding. Otherwise, our civilization will stagnate and die. And a few years later, in another Supreme Court case, the court held that the First Amendment does not tolerate laws that cast a pall of orthodoxy over the classroom. And these cases stand for the notion that the Supreme Court takes the rights of faculty members very seriously, academic freedom as a right protected by the First Amendment, and just we want to ensure that any laws or regulations seeking to rein in the DEI programs and activities of government agencies don't cross these bright constitutional lines into affecting the clearly protected First Amendment rights of faculty members to teach in their classrooms.